Your Honor, Jaden Ross.
Okay, all right.
Oh, I'm so sorry. I'm sorry. You go right over there. I apologize.
Judicial building security.
Thank you, Your Honor.
All right, y'all ready?
Yes.
Okay, all right.
Your Honor, this is Jaden Ross, charged with murder, aggravated assault, and possession of a firearm during the commission of a felony. This happened on April 28th, 2021 at 4314 Aintree Road, Epswood, Georgia. Because of this defendant's uncontrollable rage, a 20-year-old girl, a daughter, sister, a friend, is dead, shot in the head in her own home, after this defendant came there to declare that if he couldn't have her, no one could. On April 28th of this year, the victim was FaceTiming her best friend when she heard a knock at the door. She opened the door to find the defendant in a rage. This defendant is her ex-boyfriend, and he had been trying to get back with her for nearly a year. He immediately started an argument, yelling and cussing at her. The friend remained on the FaceTime call and observed the defendant get physical with the victim, pulling her hair while she screamed for him to stop. The victim got away and threatened to call the police, but the defendant had not finished what he came there to do. The victim went to the kitchen to grab a knife. That blade was meant as a defensive weapon, a warning to leave her alone. But the defendant had come prepared. He had a handgun. And when she called him out for being a, quote, pussy and pulling a gun, he shot her. He shot her once in the face, just below the jawline. She fell to the ground, face down. He then shot her again in the back of the head. Now we know three things that prove this was an act of malice and not of self-defense. First, the victim was backing away from the defendant, not moving aggressively toward him. Second, the defendant moved toward her to fire the original shot. This is proved by stippling from the barrel of the gun, which indicates close contact. Finally, the defendant fired a second shot, no evidence of stippling, indicated that he stood over her like an executioner. Police found Brinley Kitchens lying in a pool of her own blood, gargling for help, suffering. Police received a call from the defendant's grandmother, who obviously did not raise him this way, because after he confessed to shooting the victim, she told him to turn himself in. He did not, and instead went on the run. Columbia County deputies located and took him into custody about an hour and a half later. Unfortunately, we do not have video of that arrest, as the Columbia County Sheriff does not outfit his officers with body cameras or dash cameras for the vehicles at the scene. Witnesses have provided statements that this defendant had trapped the victim in a cycle of abuse, having gotten physical with her on previous occasions. While his only documented criminal history is juvenile, he does have a history of violence and felonious activity. The state deems this defendant a threat to the community and a substantial risk of intimidating witnesses. Judge, given the way that he treats women, and with all our primary witnesses being women, we would fear for their safety and the integrity of the process were he released. We ask Your Honor to deny bond. The mother is Lauren Kitchens. She is here, and we ask that the court hear from her after the defense's presentation.
All right, thank you.
Thank you, Your Honor.
Okay.
Yes, Your Honor. I did just want to start by addressing, obviously the state does have a lot more information than we have right now, but from the little bit that we do know, without having really received any discovery yet or anything like that, there is, and I know that this is a bond hearing, we're not here to have a trial, but there is evidence that the deceased in this case did have a knife. I understand the state is already making their case about how it wasn't self-defense, but at this stage, I do ask that Your Honor consider that. I mean, with the information that I have, it sounds like there is more that needs to be explored about exactly what took place and what order things took place. That's about all I'll say about the facts today, because I do understand that we do not have discovery yet and we do not know.
How old is Mr. Ross?
My client, Your Honor, is 19 years old. And so I've spoken with his family. I know Kari Talley with our office, who also is representing him right now, has spoken with them. And I know that his boss is here today as well. That my client, He's grown up here. He did attend Greenbrier High School. He's been going to St. Teresa's Catholic Church his whole life. These are his grandparents are his legal guardians, and have raised him and taken care of him. His little brother is also here today in court. And just to speak to his boss, my client is a pool cleaner, and he basically a pool technician. He works for Ken's Pool Services. He's been doing that for the past 3 years. And I believe Kenny Murray is here today in support of him, just that he is a good worker, and has a good family, has strong ties to the community. And it's something where if Your Honor was willing to consider a bond in this case, it could really be with any level of restriction that Your Honor wanted. He could be living with his grandparents. He could be still working. And it's something where that could basically be all he was doing. I understand the serious nature of the charges. However, I also, Your Honor is well aware of where we are in the proceeding and at what stage we're at. And so we're asking Your Honor to consider a bond. If Your Honor has any other questions, more specifically, if Your Honor is considering a bond but has some concerns, the family is here to answer those questions and go into any detail. His boss, like I said, is here to go into any detail of anything that Your Honor would be willing to consider. So I just want to kind of leave it at that. I know it's a tragedy. There's a lot of emotions, but what we do know is that the deceased did have a knife. We haven't gotten into all that yet, but the family is here if Your Honor has more questions.
All right, thank you. All right, DA, what else? You want to
Your Honor, just
hear
to,
from some of the family?
absolutely, just to introduce
Yeah,
the victim's mother, Ms. Lauren Kitchens.
okay. Yes, ma'am, would you raise your right hand, please? Tell us, you swear or affirm anything you may tell us for the truth, whole truth, and nothing but the truth. Okay, first of all, sorry for your loss.
Thank you.
I can't imagine what difficult losing a child outside of the,
Thank you.
that's what none of us expect.
Okay,
We're all
sir.
here, yes, here. What would you like to say?
On February 16th, 2001, I had Brinley. Brinley was a joy. She was an advocate in our community. She was an athlete. She was loved very much. And she was taken way too soon and way too young. And I asked you, please, you, I'm scared of our safety. And I just plead with you not to grab on. That's all I can really say.
Thank you, ma'am, appreciate it. Anything else, Jim?
No, Your Honor. Thank you.
Anything, Mr. King?
Does Your Honor have any questions for my client?
I don't think so. I appreciate it. I understand the position, and I respect your position. I realize it's early in this case, but based upon what I know of the situation, I think there is a threat to witnesses as well as the safety of the community. And at this point, it's early in the stage, and certainly we consider later on as more information comes to light. But for now, I'm going to deny bond.
With that, can I just ask one question, just
Sure.
to kind of clarify? I know Your Honor just indicated something about reconsideration, but also just for Jaden's benefit, the state in their presentation did basically talk about a lot of potential evidence and a lot of things for why they were kind of coming to the conclusions they were coming to. So when we start to get that stuff, would it be something where we could ask for another bond hearing?
Well, I mean, I think that bond is always a matter that you can reconsider at some point.
Yes.
And the case will go to the grand jury and eventually be assigned to the judge. And so it's an ongoing process. I don't think any judge wants to hear a bond hearing every week. But certainly as matters come to light,
Yes, Your Honor.
my position, and I think the position of most judges will be, it's an ongoing matter, and things change, and I recognize now the difficulty we're having with cases that are behind and trying to get cases through the system,
I understand.
and I had did one a few weeks ago where someone had been in jail 2 years and still can't get to trial, so I recognize that. So nothing is done with prejudice to
I understand.
your ability to bring it back, but obviously, as I said, it has to be something that change the, change the parameters of what we're looking at. So,
Thank you, Your Honor.
all right, thank you.
And Jaden, we will, when we get things, we'll go from there, okay?
All right,
Thank
That
you.
concludes my business, Mayor.
all right, thanks, appreciate it.
Your Honor.
Thank you.
Your Honor.
Yes, yes, sir.